discuss are sometimes it's not best to leave things outright to beneficiaries, even perhaps to a spouse. Now, some people might say, well, why wouldn't I leave things outright to my spouse? Answer might be, maybe you're up there in years. Maybe your spouse is not well. Maybe they're on Medicaid. Maybe they shouldn't be receiving assets outright. Maybe the receipt of assets would disqualify a beneficiary or a spouse from being eligible for governmental assistance or Medicaid. So sometimes we discuss not only trusts in the will, but different types of trusts, because I always discuss with clients and people and at seminars like this, that in my office, we prepare about 60 different types of trusts, and they all serve different functions and goals. Sometimes we create trusts because we have young or minor beneficiaries, and it's not appropriate for a youngster to have a great deal of assets or money in their name or under management. And maybe it needs to be held for their benefit by someone who's a little bit more responsible. Sometimes we put things in trust because people are, we have spendthrift worries. They can't handle money no matter what age. Or maybe there's a substance abuse problem. Or, like I said and alluded to before, maybe someone is disabled and we're creating a trust to preserve their eligibility for continued governmental assistance. So, the will, which, seems like a very straightforward, typical document, sometimes gets a little bit more complicated when we're sitting down and talking about it and fleshing out people's concerns and goals and wishes. Moving on from the last will, the health proxy, so important. And, we've seen it, especially in the last couple of months, where people have been, unfortunately, a lot of our clients been in assisted livings or nursing homes and have been, and I got to tell you, there was a point about 2 weeks ago where I was getting panicked, crisis, actually awful phone calls. And I would tell you that all the attorneys here were having clients, unfortunately, they were passing away, maybe one a day at these places. It was absolutely terrible. And, it became clear that at least the people that had their planning documents in place, like a health proxy, had the right people named to make decisions. Because that's what the health proxy is. It's a document that creates a principal-agent relationship. You, the principal, appoint an agent. Usually spouses appoint each other to speak for you regarding health and medical decisions, but only if for some reason you can't communicate your wishes yourself. If you're able to talk, you can wink, you can nod, maybe you can't speak, but you can communicate somehow. You're in charge of your own health and well-being. It's only in the circumstances where perhaps you're unconscious. Maybe the doctor gave you pain relieving drugs and you're not thinking clearly. Well, if that's the case, then you've appointed an agent to speak on your behalf. And like I say, usually a married couple will name each other. Usually that's academic. The tougher question usually is, who's the alternate for you if your spouse is unavailable? And, most people say, oh, it's my kids. And I go, well, let's slow down for a minute, because, this is about as thankless a job as it gets. When you're the healthcare agent, you might be asked to make life and death decisions. Not fun. Believe me, my mom has myself and my sister. We're the two children, and she's named me as the healthcare agent, mostly because I'm up here in New York with her. My sister's down in Baltimore. Lucky her. Believe me, if I had my choice, I would make my sister the healthcare agent, but it doesn't make sense because from a strictly decision-making and geographical standpoint, if heaven forbid my mother was to be rushed to the hospital, I would be in the better position to go to the hospital and speak to the doctors. One of the things that you have to consider is that a doctor listening to a healthcare agent, they want to know they're talking to the right person. And if they're talking to my sister over the phone, how do they know it's my sister, right? I mean, how does she prove that she in fact is the right person? So, a lot of times you have to physically be there in front of the person with the document to be able to show the emergency room physician why they're speaking to you on behalf of mom. Anyhow, the healthcare proxy, you appoint an agent, an alternate agent, and it's not sometimes so straightforward as you initially think. The third document that kind of goes hand in hand, it's a sister document to the health proxy, is a living will, not to be confused with your last will. It's a document that expresses your wishes of what you would want, and sometimes, just as importantly, what you would not want if you were ever diagnosed to be in a permanent vegetative state. A typical living will reads something like this. It reads, to my friends, to my healthcare agent, to my attending physician, to anyone who's interested, if I'm ever diagnosed to be in a permanent vegetative state, not temporary, I will have no meaningful existence. The only reason I would be kept alive is because they would put a feeding tube in my belly. I would be on some kind of machine, a ventilator perhaps, with no understanding. I will never understand what's going on. I'll be institutionalized for the rest of my days as these machines keep me alive. Keep me out of pain, but let me go in peace. Don't use heroic measures to keep me around. So this is the typical living will. We'll tailor this to read whatever you want. Sometimes I have clients that say, no, that's not what I want. I want to be kept alive no matter what. I'll take body part donations. I'll take experimental drugs. By the way, that's fine. We'll tailor this to read however you please. But really what it's designed to do is to give instruction to your healthcare agent. So you're taking some of the burden off of them as to some perhaps terrible decision making that may need to be made. Any case, that's the living will. The fourth of the basic documents, power of attorney, is perhaps the most important, even sometimes more so than the last will, which disposes of your property when you're gone. The power of attorney, again, is a document creating a principal-agent relationship. You, the principal, are appointing an agent, this time not for health decisions, but for financial and money management decisions. This is the document where you're appointing someone and giving them the keys to the kingdom. And you're letting them stand in your shoes. And anything that you can do, this agent can do. Why is this so important and why is this a necessary document? Well, I'll tell you why. Because every day, including during this pandemic, and especially during this pandemic, we've been getting calls and they go something like this. Aaron, I got bad news. Mom is in the hospital, but you know what? She's not doing well. They're releasing her to the nursing home. And quite frankly, it's a horror show because she, physically needs to be there. Mentally, she's not well. She's going to maybe be in the nursing home for the rest of her life. And, I spoke to the administrators and they told me the cost. And in case you aren't familiar with the costs of the nursing home, the average monthly, and I underline monthly, cost of being in the nursing home is anywhere between $15,000 to $17,000 a month. So the question is, well, how do you pay for the nursing homes? And the answer is there's really four ways. And the first way, most common way, is Medicare, although it only has a limited benefit that could pay up to 100 days. After that, you're backed into the three ways, which are next, long-term care insurance. And I always encourage people to speak to their insurance agents and discuss different policies. The resistance I usually hear is that it's too expensive. I may never need it. What if they go out of business? I've heard people that they change the premiums after many years. So there's a lot of resistance. The insurance company's response has been to some of this resistance. Well, now what they'll do is they'll sell a life insurance policy with a long-term care rider. And that kind of takes care of the worry of, well, what if I've been paying these premiums and I never need them? And I say, well, good. That means that you were healthy. This response of having a combined life insurance and long-term care means that, someone will benefit one day. It's not all for naught, these premiums. But again, the second of four ways to pay for the nursing home is to have long-term care insurance. The third way is, of course, the worst way that we usually try to avoid, which is privately paying for the nursing home. And that's where you're writing a check for $15,000, $16,000 a month, which leads us to the last way, which will segue into back to the power of attorney, which is, to have Medicaid available to pay. And to qualify for Medicaid, an applicant has to pass three tests. Number one, you have to be in the nursing home with a medical need to be there. Number two, you have to be financially eligible. What does that mean? Well, it means, as most people kind of intuitively know, it means that you have to look, quote unquote, poor. What's poor? Well, poor this year, and I purposely say this year because it changes from year to year. This year, you're poor if your assets do not exceed $15,750. The third test, and that's not income, those are assets. The third test is something that most people have read or heard about, and that's the 5-year look-back transfer penalty rule. And that rule, most people have read about. It reads that when you apply for Medicaid, you must submit financial records for the immediately preceding 5 years. They want every bank statement, investment statement, tax return, deeds, everything in your financial life for the last 5 years must be disclosed. If you do not disclose it, Medicaid will deny you for lack of records. So you're going to disclose it because it's worth $15,000 of payment to the nursing home each month. So when you disclose this, what is Medicaid looking for? Why do they ask for it? They're asking for it because they're looking to see if the applicant in this 5-year look-back period gave things away. Because if they gave things away, Medicaid assumes the worst in us. They assume that if we gave things away in the last 5 years of applying for Medicaid, that we did this purposely to try to look poor, to pass test number 2 to qualify for Medicaid and look like we have assets below $15,750. Now that's a general rule, and it's true. You make gifts within the last 5 years, you get punished. And the punishment is a period of time that you're deemed ineligible. Of course, this period of time varies based on how much you gave away in the 5-year window. So point of fact number 1, if you gave away $2 million 6 years ago and you have nothing, and that's been the case for the last 5 years, when you apply now, they look back, nothing's happened. 6 years ago, the fact that you gave away $2 million, that's fine. And that's why people come to the attorneys, hopefully well in advance to do planning. Now, I'm not suggesting you give away your fortune to the kids or to the family now. That I would never recommend that. There are smarter ways, and that's why, people sit down with me and we talk about trusts, because there's smart ways to have things look like they're out of your name, yet retain measures of control. And that's always the balancing act that we're having to deal with clients. And I totally understand it. So the third test is the 5-year look-back transfer penalty rule. And as I said, that's a general rule. One of the biggest exceptions, however, to the 5-year look-back transfer penalty rule is transfers between spouses. So if I got the phone call from the spouse saying, Aaron, I got bad news, my wife is going into the nursing home, I would say to the husband, the healthy husband, I'm sorry, that's awful. However, assuming that you have the power of attorney in place, what we're going to do is we're going to take everything that's joint with you and your wife, or anything that's in your wife's name effectively, and we're going to transfer it to you. We're going to make your wife look poor. Next month, she's eligible for Medicaid. And then usually the husband has that look like, aren't they going to see that in the 5-year look back? And I'm going to go, yeah, they're going to see it. Absolutely. They're going to see all the transfers. However, in the application, we're also going to show them the marriage license. Transfers between spouses, even within the 5-year window, are not punished. But the key to this planning is having the right legal tool to make these transfers so that when you go to the bank and you make that joint account into the husband's name, when the banker says, well, where's the missus? She's been a customer of mine for 20 years. Why am I giving you the money, healthy husband? Say, look, here's the power of attorney. I'm allowed to sign things on behalf of my wife. Please help me out. I don't have time to explain the what-fors right now. So the power of attorney is a legal tool that could save the day if there was a crisis and the right circumstances exist. The right circumstances in this situation being that there's a healthy husband or a healthy spouse. But let's assume even further. Let's assume that back to my original case scenario, which was that the kids were calling me, that there's an ill mom, but there is no healthy spouse. Oh, man, I'm getting a question here. Okay, it's not a question. In any case, the reality is that if there is a child that has the power of attorney, and when I say power of attorney, it's got to permit unlimited gifting. And this is what's known as the statutory gifts rider that permits unlimited gifting. In the worst case scenario, with the right legal tool, the power of attorney, at worst, we could save half of that applicant's assets. That's the worst case scenario. And sometimes we could even do better. The reality is having the right legal tool in place to make the appropriate manipulations at the time of crisis. And that's the power of attorney, such a critical document. Moving on, and I'm growing short of time here. I want to mention something that I alluded to before, and that is the fifth document that we often speak with clients about, and that is a type of trust that's designed to protect assets if someone were to ever need Medicaid in the future. And that's something called, and I hate the title of this, it's called an irrevocable trust. And I hate the title of it because that word irrevocable scares people from doing smart, wise planning. And it has to be designed to be an irrevocable trust to accomplish the legal goal of protecting assets. But I always have to explain to people that even though it's quote unquote irrevocable, believe it or not, the law permits you to revoke an irrevocable trust. So if it's designed right, the client always has the ability to revoke the irrevocable trust and always can maintain measures of control over the trust so that there's ways to protect from different unknowns and fears. Now, sometimes people say to me, well, why do I have to pay all this money to the attorney to create this fancy trust? Can't I just give things to my kids now and 5 years later, isn't everything safe? And I go, yeah, you're right. Absolutely. That's absolutely the truth. If you can give away everything to the children, the house, money to the kids now, 5 years later, if you ever needed the nursing home, not a problem. But I tell you, don't do it. What are you, nuts? You can't give the house to the kids. You can't give your money to the children because only bad things are going to happen. What can happen? You know, because people always say, oh, not my kids. They're superstars. I've heard that many times. Well, even if they are superstars, and I'm sure they are, bad things can happen. What bad things can happen? Well, you transfer things to the kids, and maybe your daughter, while she's driving one day, the phone rings, she looks down, and boom, she hits someone, and now she's got a judgment or a lawsuit against her. She also has your money in your house. Guess what's available to collect against this? Your money, your house. You don't need this. If you want to talk about sleepless nights, another thing that can go wrong, you give things to your kids, maybe they get, credit card troubles or bankruptcy issues. This could be a problem if they own your property, your assets. Another thing that can go wrong, you transfer things to the kids, your assets. What if they now get into matrimonial or divorce problems? Guess what's, could be mixed in some kind of matrimonial or divorce proceeding. Who needs this aggravation? Trying to do the kids a favor, by the way. Because at the end of the day, the only people that will really benefit from planning are your kids, your grandkids, because when you really take a step back and think about it, if you had to spend your assets in order to qualify or to pay for the nursing home, and then become poor once you burn through it, and then we're eligible for Medicaid, either way, you're going to be cared for whether you had to privately pay until you were Medicaid eligible or you were Medicaid eligible to begin with. The key difference, of course, is I assume that most people would prefer their things safe and given to their kids or their grandkids versus the owner of a nursing home if they had their choices. So the last thing, of course, that can go wrong, the worst perhaps, is you transfer things to the kids and heaven forbid one of your children predeceases you. Where does it go? Maybe the things that you gave to your daughter, she leaves in her will to her husband, your son-in-law, and now your son-in-law owns your house and he says, get out. I've been waiting for this for a long time to tell his mother-in-law, get out, because he now owns your house. So at the end of the day, could you give things to your kids and 5 years later, does it work? Absolutely. It's not smart though, because there's too many variables, there's too many unknowns. Trying to do your kids a favor. The smart way to plan is the trust planning. I wish I had more time to get into it. The other thing I want to mention, and this is something that's newsworthy and some things that have changed. What we've been talking about generally is something called chronic care Medicaid, which pays for someone to be in a nursing home. New York State has a second type of Medicaid program, which is called the community-based Medicaid program. And community-based Medicaid, if someone is eligible, will pay an agency, a home health care agency more specifically, and they will send home health aides to assist someone in their house if they need help with the activities of daily living. What are the activities of daily living? The activities of daily living I always describe as the things we take for granted, waking up in the morning, getting up out of bed, transferring from the bedroom to the bathroom, using the toilet, showering. They'll help with, cooking, some, simple cooking, dressing oneself, cleaning. These home health aides could be paid for by Medicaid if someone qualifies. How does someone qualify for community Medicaid? Well, number one, you have to have a need. That gets determined by an assessment that someone from Medicaid, a nurse, comes to visit. At least now they do. Another requirement is that you have to look poor. Same definition as chronic care Medicaid, assets less than $15,750. And now here's the big change, right? Look back penalty rule. It used to be that for community Medicaid, well, for chronic Medicaid, we know it's a 5-year look back. You need help in the nursing home, they're going to look at your records for the last 5 years. It used to be for home care, believe it or not, there was a 0-month look back, meaning people could give things away today, next month, if they're poor, they were eligible. Now, since this budget change, there is now a 30-month look back, a 2.5-year look back. So if you need help in the house and you have given things away in the last 2.5 years, the last 30 months, they're going to punish the applicant again for a period of time from being eligible. And that period of time again will vary based on how much they gave away in that 30-month look back. So one of the big changes is the 30-month look back. The other changes that have come up with community Medicaid has to do with the assessment. And it used to be that a person's primary physician letters needed to be effectively given to Medicaid showing a diagnosis of disability. Now the state is pushing an independent evaluation by one of their doctors. So they're making it more and more difficult to get these benefits, which have been available for a lot of people. So there's been a lot of changes in this, and the effective date of these changes is October 1, 2020, which means if you apply for community Medicaid after October 1, they're going to have that look back. If you apply prior to that, you might be lucky, and you would be lucky because the rules are they don't apply yet.